Welcome to the latest episode of Risk Settlement's podcast, Alternative Litigation Strategies, where I interview esteemed members of the bar on the latest trends and developments in the world of class actions and other types of commercial litigation. I'm your host, Kevin Skrzowski, with the litigation consulting firm Risk Settlements, and today we'll be discussing a topic that I find incredibly interesting: 5 mediation mistakes that create obstacles to settlement. I'm very pleased to be joined by former practicing attorney, now independent arbitrator and mediator, Rachel Gupta, owner and principal of Gupta Dispute Resolutions. Rachel, good morning, and thank you for joining me here today.
Good morning, Kevin. Thanks for inviting me.
Now, I normally start by asking the guests to tell us a little bit about their career, and I think it's especially important for our conversation because you started your career as an outside counsel, then you transitioned and you went in-house. Tell us a little bit about that.
Sure. Yeah. So before I was a mediator, I was really a commercial litigator here in New York. I started, as you said, as outside counsel. I was working for firms here in New York City, primarily as a general commercial litigator. But I had a concentration in financial litigation, securities class actions, insurance, and some employment work as well. I represented parties on both sides of the table, plaintiffs and defendants, public and private companies, as well as individuals. And then in 2010 is when I was offered a position with Ambac Assurance Corporation as one of their first 2 litigation attorneys. And Ambac was a financial guarantee insurer that guaranteed both public finance and structured finance obligations. But when I joined them, they were really in the midst of a lot of turmoil due to the financial crisis. The insurance company was in rehabilitation, and the parent company filed for bankruptcy on my 1-week anniversary. So there was a lot going on at the company. I was there approximately 9 years, and during that time, I managed high profile and some bet the company litigation relating primarily to residential mortgage-backed securities, but as well as derivative and securities class actions, allegations around RICO, and other commercial litigation. But as many in-house counsel know, you wear a lot of hats. So I wasn't just a litigator. I worked with departments really across the company, from advising the board of directors to being a liaison with the insurance rehabilitator to working with the trading desk on policies. I also, broadened my experience in terms of working on compliance and data preservation with the IT group or advising HR in different types of employment claims. So it really ran the gamut. But it was a lot of interesting work, and that's really where I was until I decided to transition to becoming a neutral.
Sounds very interesting in that you had a very diverse background handling a variety of different types of commercial litigation matters, both as outside counsel and as corporate counsel, and then not only handling legal matters, but handling a lot of business matters as well for the company. Now, you touched on this, I think, a little bit after your 9 years of service for the company, but why did you decide to transition from becoming a practicing attorney to a neutral and found Gupta Dispute Resolutions back in 2020?
So, Kevin, I had spent almost 15 years litigating very contentious cases. And candidly, I got to the point where I was tired of being engrossed in conflict every day. Some of my cases were going on for a decade or more. And I wanted to be part of a solution to try to help parties find ways to resolve their conflict and move forward. In hindsight, this transition wasn't a huge stretch for me, given my role in-house. Because if we think about it, I was sort of an informal mediator at times when I was in-house counsel, whether it was acting as liaison between outside counsel and the C-suite or working with the business department through legal implications of certain strategies. I was in a role that required me to work with people at all levels of the organization, from the board to junior employees, each with different levels of knowledge and different personalities. So in hindsight, it's really not that different in some ways from what I do now.
I think that makes a lot of sense. And your message actually really resonates with me because while I am a litigation consultant and we help people to do litigation risk assessment and put together settlement strategies, not actually practicing. I like to call myself a recovering attorney, and we have a lot of recovering attorneys here, both on the plaintiff side and the defense side. We're still involved in litigation, just not actually doing the day-to-day arguing ourselves, which is quite a relief, actually. Now, before we get into the 5 points you raise in your article, just generally speaking, what are some of the challenges and difficulties in the mediation process? And what are some of the criteria that you would advise counsel to consider when trying to hire the right mediator or select the right mediator to help them achieve a resolution?
So sure, Kevin, first I want to say part of what motivated this article was because having the different perspectives of outside counsel, client representative, and as a mediator, I realized that participants in mediation don't always realize how their behavior directly impacts the outcome and success of mediation. And I see certain behaviors kind of over and over again that tend to be counterproductive to settlement. So my goal for the article was to identify some of those most common mistakes that create obstacles that are totally within the control of the participants so that they can be more effective in mediation. And then so in terms of the challenges and difficulties in the mediation process and the criteria for choosing the right mediator, I also want to take a step back and talk about how counsel usually chooses a mediator. And that's they turn to historical relationships. Counsel tend to use the same mediator over and over again without consideration as to whether those individuals or that person is the right for the case at hand. And so while good mediators can mediate lots of different types of cases, this default to legacy relationship has a few consequences. Aside from the lack of diversity in the ADR field, that's a consequence of it. It's also not necessarily looking at the specific issues of the case at hand. And that's both the legal issues, but also things like the relationship of the parties or the nature of the allegations. And you should be looking at the right expertise for the case. So what are likely to be the obstacles to settlement? Is it going to be different views on the legal merits? Well, if that's the case, you may want someone who has specific subject matter expertise or sophistication to get up to speed on the legal issues of the case. Is the biggest challenge to settlement really difficult personalities or a very high emotional conflict? Then it may be less about subject matter expertise, but you want a mediator who has the right temperament for the parties. Sometimes you have a really stubborn counterparty and you want a former judge who can really tell them that they're likely to lose in court, right? You want to think about the case specific questions, interview your mediators, and think about what's right. So just to kind of put it in context, the right person, for example, for a multi-tier D&O insurance case may not be the right mediator or the same mediator for a very high emotion employment discrimination case. So this kind of going to the same person over and over again may not be the right way to think about how to choose your mediator.
I think that is really great and wise advice to not simply be wedded to one, but to make sure that you select the right person based upon objective criteria of your specific case. Very, very good point there. Now, you had mentioned increasing diversity amongst the JAM mediators. I'm going to throw a little curveball at you because I know we didn't discuss this in our prep call, but you are a diversity fellow with JAMS. Just curious, what are you doing with JAMS to increase the diversity across the global panel of neutrals in order to perhaps help attorneys select the right person for their particular case?
Sure. So Kevin, I think JAMS as well as other ADR providers are taking steps to increase diversity among their rosters. It really is inherently a problem that goes back decades, because if you think about who historically had gotten into the ADR field, it very much was retired judges or retired law firm partners. And historically, there wasn't a lot of diversity among those ranks. So what companies like JAMS and AAA and CPR are doing is really ensuring and kind of recruiting more diverse neutrals to be on their roster to make sure that it's more representative of the constituents that they serve. I actually, coincidentally, just published an article recently, earlier this week, talking about ways that counsel can start making small changes, in-house counsel, start making small changes to help increase diversity in selecting neutrals. Things like just being very intentional about thinking about this issue when they're interviewing mediators or neutrals, kind of vetting folks before there's actually a demand, before there's actually a conflict, so that you can keep people in your back pocket. Considering co-mediation as opposed to just one mediator, you have the insight of two, and it gives you an opportunity to try somebody new that you're a little bit more unsure about, but you think is going to be good, but you don't want to take a gamble on a big case. Things like that. For arbitration, there's ways to do it as well in terms of appointing your party selected person can be a diverse arbitrator, or you can have the party appointed arbitrator select a diverse arbitrator for the chairperson role. There's lots of little steps. It really just comes down to counsel being intentional and thinking about the issue.
I love that. And I know that is very top of mind for in-house counsel across the country. I just came from the Legal Leaders Conference in New York City this week. And top issues that were discussed were, of course, were like global governance, social justice, increasing diversity among both inside and outside legal teams, and then, of course, environmental issues. So if you would be interested, I would love to have you back. And I think that's a whole nother podcast episode on what you're doing with JAMS.
Yeah, I'd love that.
Now, going back, you had mentioned the motivation for writing the article and mistakes that lawyers make. And one of the 5 things that you list was failing to adequately prepare for the mediation. So obviously, you've seen this, but I mean, how often do you really see this in real life when the lawyers are there and their clients are present and they're ill prepared for the process?
It does happen. And, I can say, you mentioned that you're a recovering litigator, so am I. So I can say this. When you've been living and breathing a case for years, you think that you know it inside and out. So you may not think that you need to prepare very much for mediation, but it's actually wrong. So first, if you've been living and breathing a case for years, you candidly may be a little too close to it. So you've convinced yourself of certain truths and may not be seeing the case objectively. An example is you uncovered a bad email in your case 2 years ago. You spent the last 2 years getting comfortable with that email. You've figured out an explanation. You figured out a strategy of how you're going to handle it if this goes to trial. But the reality is, if you go to trial, the judge or jury won't have 2 years to sit with that document. So before mediation, you need to kind of take a step back and remember how the other side is going to play their hand. So there are certain things that counsel and their client should do before mediation. And I do see sometimes that the parties just are maybe a little overconfident in thinking that they understand the case and they don't take these steps. So you should sit and evaluate your chances of success. Consider your adversary's arguments and what your responses may be. Think about how these issues may present obstacles to settlement. And just, again, it's about being strategic. You need to just think about your strategy for the day. You can't predict exactly what your counterparty is going to say or numbers they're going to throw out, but you can plan for various scenarios and step into their shoes and prepare for issues that may come up. I would also say that outside counsel really needs to spend time with their client, preparing them for what to expect. And that's both in terms of the mediation itself, but also for the remainder of the case and at trial. It is a mistake not to discuss the financial and emotional toll that trial can take, not to mention the amount of time that your client's going to have to commit to actually go through trial, both in preparation and during the trial itself. So over the course of litigation, clients may start to feel very strongly that they're going to win at trial. But counsel should take the time to talk to them about how most cases actually don't go to verdict, right? They're going to settle at some point. And even the strongest cases have some level of risk. So mediation and settlement provide the parties with a chance to eliminate that risk and achieve certainty. And there's a value to it. You need to take the time to actually calculate that, put an economic value, attach it to it. And then, the last thing I would say, and this is just kind of something to prepare when thinking about your opposing counsel, know who you're negotiating with. And if you can have some form of working relationship with them before the mediation, that's always beneficial. But the flip is true as well, that if in the course of litigation, your relationship with outside counsel has really deteriorated, outside counsel for the other party, then think about whether or not you and your client could be benefited at mediation to have someone other than lead litigation counsel be the face at mediation and be the main voice speaking in a joint session. And what that does is it can send a real signal to the other side that you're there to collaborate. It's kind of positive optics and an olive branch right at the start.
Rachel, that's very interesting. So you're saying that when lawyers walk in and perhaps they are ill prepared, it's not just simply that they didn't properly assess the case. It could be that they're actually overly confident because they've been living, eating, and breathing the case and perhaps over advocating, and they lose their objectivity. But then you raise excellent points that you also have to prepare your client for what to expect, manage those expectations, and prepare them for how arduous the trial process could be. You and I understand, opposing counsel understands, Bertha, these are just civilians who are coming in, and it is an emotionally taxing process. But then lastly, that's a great point. If you don't have at least a solid working relationship with opposing counsel, it's going to be hard to get to yes when you're at mediation.
Absolutely. Yeah, that can be a real difficult challenge and obstacle at mediation when the lawyers themselves just have such a difficult relationship.
Those are great points. So now the lawyers and their clients, they come into a mediation, the process starts. Of course, there is a series of offers and demands. Who normally makes the first move? And are there any risks around doing so? And what are some of the dangers of coming in and anchoring too high or too low?
Yeah, so I think, Kevin, many lawyers worry that if they're the first to move, it might disadvantage them. So if you're the plaintiff, you worry that you could signal too low of a target and leave money on the table. Or if you're a defendant, you might signal too deep of a pocket. But the reality is, if you do your homework and are thoughtful and strategic in developing a game plan for what you want to achieve, then there are advantages to being the first to move and actually throwing down a marker. But if you anchor improperly, it can be problematic because your first offer tells the other side the general range you're targeting, right? It's if you're a plaintiff, however, if you anchor too high, if you come in with a number that isn't really anywhere close to where you expect to end up, you risk signaling that you're unreasonable. And then if you start making huge jumps downward, you're signaling not only that you're posturing, but that you're not really coming and acting from a place of conviction. Similarly, if you're a defendant and you anchor so low that it's not even considered nuisance value, you may send the message that you're going to be acting unreasonable, and you will likely very quickly trigger frustration from the plaintiff, but also a similar counter move from plaintiff that is really, really high. And what ends up happening is the parties hit impasse pretty quickly. So instead, the way you should think about this is your first number should be within a reasonable range of where you are targeting after a few moves. It should not be a universe away from your walkaway point. And what I mean by your walkaway point is the number where you decide you're willing to roll the dice in litigation. For example, if realistically you think a case is valued at, let's say, $2 to $3 million, as a plaintiff, you don't need to start at 10 million. You're also not starting at 4, but you can come in with a strategy where you don't need to be making $1 million moves or $500,000 or $200,000 moves. You can be more strategic. On the flip side, if you're a defendant and you know realistically, let's say the case is likely to settle around 5 million, starting with an offer that's 5 figures, like $30,000, is likely just going to anger your adversary. And you're going to end up with a very high number in response from plaintiff. And you're going to start doing this tit for tat or game of chicken. And it makes the mediator's job much more difficult to move people off of their positions. So it's really important to be strategic and consistent right from the start. It focuses you on your end goal, implicitly manages the other side's expectations because everyone seems to be moving in kind of a direction where they can start figuring out where it's going. And candidly, it helps me as a mediator. I, right off the bat in my mediations, promise the parties and counsel that if at any point I think a deal is not obtainable today, I'm going to tell you, I'm not there to waste anybody's time. So if one or both of the parties are all over the place with their offers, like they're completely inconsistent, I have a hard time getting a sense of what their true expectations are. And I'm having likely much more candid conversations with the parties privately. So their counterparties really have no clue. The point of mediation is not to hide the ball. It's to strategically negotiate towards an end goal. And I think sometimes that point gets lost in kind of the process of negotiating.
And to your point, you mean your points really tie into your answer to the opening question was to make sure that you adequately prepare for the mediation, that you maintain a certain degree of reasonableness and objectivity throughout the process. It's the same thing that we see when we are counseling clients and helping them to structure settlements. What are your legal, business, and financial objectives? And if you could wave your magic wand and exit this matter for a fixed cost, what would that number be? Within reason. But then to the lawyers, it's stop arguing, stop advocating your position. We're talking about business objectives, financial objectives. We want to achieve a resolution and stop arguing. And I want to ask you about that later, about the differences between mediating and actually litigating when you're in court. But you have to consider certain risk factors when you're in a mediation. And sometimes you have to put your business hat on just as much as you do your legal hat and make sure that you're properly in sync with your client, which takes me to the next point that you raised, which was not accounting for compounding risks. So can you explain the importance of and the type of a comprehensive risk assessment that should be performed so that the viability of the settlement is considered on a 360-degree holistic level and not just individual risk factors in a vacuum?
Yeah, sure. So I think this is really important. Lawyers know when they're honest with themselves and their clients that every case has certain risks, but they don't always sit down and do an economic analysis of the risk. So if you go step by step through the case from the current point in time through litigation and through trial, ask yourself the question, along this road, where do I face risk? What legal issues might go against you? How does that economically impact the value of the case? You should be doing this for each legal issue. So in each procedural stage and compound them, meaning you don't just look at each risk in isolation. You have to think about the economic scenarios such as where you lose on multiple issues. So you may win on everything, you may lose on everything, but there are varying outcomes too. And so you really need to think about each scenario. Also, if you win or lose on one legal issue, that can potentially directly impact the outcome on another. So you need to evaluate that. There's also compounding effects of procedural risk of losing on summary judgment on some issues, plus risk of losing a trial. You need to consider the total risk still ahead in the case, not just each in isolation, to help really holistically think about your estimated settlement value. I would also say I see this sometimes happen when parties mediate at different stages in the litigation, like early in the case, and then it didn't resolve, then later in the case. And something that parties hadn't considered is the timing of trial and how that might impact your chances of success in certain legal issues. So in other words, there might be potential for legal developments in case law that directly impact the value of your case. So this could be not just your own litigation, but similar cases that are pending, like an appeal from another case, that if that appellate decision comes down, it has potential to be intervening case law that's going to impact the value of your case for better or for worse. So you need to really do your homework and evaluate these multiple scenarios so that you and your client can better evaluate settlement offers during mediation. I think when counsel, I don't know that everyone sits down and really does such a thoughtful economic analysis of these kind of risks, but when you don't do so, this can lead to an inflated expectation at mediation.
I couldn't agree with you more. We see the same exact thing in our business, and we talk about risk. You mentioned risk many, many times. Risk equals cost to the client, and I think you're absolutely correct. In addition to the legal analysis, there needs to be that economic cost-benefit analysis so that you're able to make a decision as to what helps your company achieve their financial objectives in the best manner. Definitely, I think a part of the process that obviously you see that people don't engage on, thoroughly prior to a mediation, and it's something that we talk about on a daily basis. Moving on to sort of wrap this up, I want to go to two other areas, and they focus on a common theme which we've discussed here today, which is over advocating as opposed to trying to find a reasonable resolution, which is the whole point and the whole reason why people engage in mediation from the start. And that is making premature ultimatums and being overly litigious. Do you ever see people who come in and during the course of the mediation, lawyers make an offer or a demand and they say, this is best and final, or they actually threaten to end the mediation prematurely?
I see that all the time. Parties bluff, that's part of the process, but lawyers do this prematurely all the time, and it really can jeopardize the mediation or their credibility because they're not always going to follow through. So there are certain moves you can only pull once. For example, I had a plaintiff's counsel say to me, if defendant's next move is not above X, we're done. And when lawyers say something like this to me, I always kind of gently push back and question their intentions, because we're 90 minutes into the mediation and you and your client have told me you want to get a deal done and you threaten something like this. It's really not a good idea, because the reality is the other side isn't going to just meet your demand. So then what do? You either have to follow through with your threat and end the mediation, in which case you're not really knowing if the deal was obtainable or not, or you continue the negotiations and you've completely lost credibility. So that phrase best and final, that's a good example too. People use that and throw that phrase around way too often. Your best and final is when there is no other number that you will accept, no matter how immaterial. And so if you think about it, you really very rarely have a best and final. Though if you want to settle, the worst thing you can do is something that's going to end the mediation prematurely without knowing whether a deal was there to be reached, or be the boy that cried wolf. Then when something's really important to you or your client, the other side may not take you seriously.
Okay, so what you're saying is really these premature ultimatums, the only thing that they do is damage your credibility. And it's such a lost opportunity because you had the chance to really help your client that day, but you made these bluffs and then they backfired on you.
Yep, exactly.
So lastly, let's discuss being overly litigious. And I alluded that I was going to get to this question earlier in the podcast. So how should a lawyer's presentation at the mediation differ from the way that they're presenting a case to a judge or a jury?
So mediation and litigation are different. The goal of mediation is not to do a mock trial or test your case. It's to negotiate a deal. So one of the biggest mistakes is when lawyers don't recognize when to take their litigator hat off. Their role in mediation is to advise, counsel, and negotiate for their client. It is not to argue their closing statements. So overly litigious lawyers really can and often are the difference between a productive mediation session and one that leads to impasse. So if I have a moment, I'm just going to give you a very brief example.
Sure.
I had a mediation when I was an attorney, actually, where lead litigation counsel for the other side insisted on doing an opening statement at the outset of the mediation in a joint session. She came in really aggressive. She made legal arguments that she knew were hotly contested on our end. And we had been litigating this case for years. The parties were all sophisticated. We knew each other's arguments. There was no need to make the statement. So while we were already skeptical of whether or not this mediation was going to be worthwhile, all she did was confirm for us this may be a waste of time. So the mediator ended up having to spend a ton of time that morning calming us down and trying to get us back to like a neutral state, but the damage was done. So needless to say, it just frustrated the process. There was zero signal from her that she and her clients were there to be reasonable and collaborative. So it undermined really the entire purpose of the mediation right from the start.
I think that's a great story and a perfect example of being overly litigious. Very interesting. Well, Rachel, I think that concludes our program for the day. It was a real pleasure having you as my guest and discussing the 5 mediation mistakes that create an obstacle to settlement. I think the audience is going to find the content of our conversation incredibly valuable and very useful.
Thank you for having me. I really appreciate it.
Definitely. Now, if anybody would like to contact you to discuss anything that we covered here today, what would be the best way to reach you?
Sure. They can reach me. They can email me. My email is rgupta@guptaresolutions.com. They can also call me at 917-597-1690. In addition to my private practice, I am on state and federal court ADR panels for mediation, as well as the AAA and CPR. So you can find me there as well.
That's terrific. And of course, I would also like to thank the audience for listening. If you'd like to hear more, please be sure to follow us on Apple, Spotify, Stitcher, or anywhere you listen to your favorite podcasts. And if you'd like to listen to a recording of today's program or learn more about the litigation and risk settlement solutions that Risk Settlements provides, please visit our website at www.risksettlements.com. And you can always reach out to me directly at kevins@risksettlements.com. Until next time, thank you for listening.